Bueno, un minuto más tarde de lo previsto, pido disculpas.
A minute later than we expected. I'm sorry. Claimant has the floor.
Tribunal, good afternoon. Before I begin, I wanted to take a moment and thank the Tribunal, thank Madam Secretary, thank my colleagues from Curtis, and of course the representatives of the Dominican Republic for all the hard work that got us here. But we are here now. And I would be remiss if at the beginning I didn't address a comment that was raised by someone who I respect a great deal, my colleague on the other side, La Doctora Frutos Peters. And one thing I know about La Doctora is that she's a zealous advocate. And I appreciate that zealousness. And like her and her team, individuals that over the years I've come to respect tremendously, I hope that Curtis, La Doctora Frutos Peterson and her colleagues recognize that we too are zealous advocates. And sometimes, regrettably, zealous advocacy can leave the false impression that somehow there's a lack of professionalism. We are aggressive litigators. I know your team is as well. But we always endeavor to be professional, and we think we have been. And I can appreciate that sometimes statements are taken out of context. I can appreciate that there may be a vision with respect to that level of professionalism. But I can tell you, as the individual that's leading this team, that every member of this team respects that professionalism and lives by that professionalism. But in a dispute such as this, there is frustration. And in a dispute such as this, frustration grows with the passage of time. We're talking about an investment that was militarily intervened over 700 days ago. We're talking about an investment, a request for arbitration that was filed 700 days ago. And here we are, almost 700 days later, with a myriad of documents that have been filed, arguing about 2 paragraphs in a treaty. And the fact that we, in that discussion, draw parallels to cases where the respondent has been represented by Curtis isn't a lack of professionalism. It's an effort to highlight those parallels, to highlight the arguments that were posited there, and that in some instances were unsuccessful, and to draw those parallels for the aid of this tribunal, which is what we've done and what we will endeavor to also do this afternoon. But this process got kickstarted with the memorial of the Dominican Republic concerning its objection to jurisdiction dated 6 May 2019. And it didn't take long. It did not take long before the respondent launched an attack on Mr. Lichin. It's not in paragraph 1, but it is in paragraph 2. And I'm going to jump to Spanish for purposes of the translation, and I will read what the respondent said in paragraph 2.
This is the case of an individual, a wealthy individual, who, as an alleged indirect investor in a business for the disposal of solid wastes, tries to increase his wealth, submitting a claim against the Republic, a claim that has no juridical or factual base.
Mr. Lichin's claim is a fraud. In other words, we, as advocates for Mr. Lichin, are an instrument to perpetuate that fraud. I disagree. Jumping to Spanish.
Paragraph 3. Both in the request for arbitration as well as in the demand brief, the claimant has told an elaborate story to try to convince this tribunal that Mr. Michael Anthony Lichin is a serious and wise investor.
Chin has filed declarations in this action. If they genuinely believe that he's not serious, that he's a fraud, they had the opportunity to call him, they had the opportunity to cross him. But they have not done that, and they are not doing that. Because all you need to do, and they know this, to determine the seriousness of Michael Lee-Chin is to go to Wikipedia, to Google him. Because what you will see is that he's a self-made billionaire. He didn't inherit his millions. He made them himself. And in the years that it took to amass a fortune which he created, he's invested in multiple countries, he's invested in multiple industries, and he has been philanthropic in many respects. So in paragraph 3 of their first jurisdictional submission, to challenge this gentleman like they do is something that I don't take as unprofessional or inappropriate. I take it as zealous advocacy. I disagree with the affirmations that were made, but I appreciate the spirit in which they were made. And with that, I'll turn to why we are here. And as I noted just a moment ago, we're here to discuss, in large measure, 2 paragraphs in a treaty. And our contention, and I heard the opening statement provided by my good colleague, La Doctora Frutos Peterson, and her colleague, La Doctora Alvarez, to try to provide some color and interpretation with respect to what this provision means. Through the submissions that were made by the Dominican Republic, and through the argument that was posited earlier this morning, we contend that with respect to these 2 paragraphs, what does the Dominican Republic want? How do they interpret them? Well, first of all, and I think it made clear in the argument that was posited this morning, in their mind's eye, paragraph 1 in truth means nothing. We can eliminate it. It's not consent. Somehow, if we take it to its most illogical conclusion, it mandates that the investor bring 3 separate actions in national court, in domestic arbitration, and in international arbitration. So they wrote all of these words for nothing. They're there as maybe a guide, maybe illustrative of something, but in the end, they give it no weight. And with respect to paragraph 2, we saw in the opening presentation of the Dominican Republic how they endeavored to incorporate words to try to give meaning to what we were asking this tribunal to interpret. We believe the opposite is true. We're asking the tribunal to look at that provision, look at its terms, analyze them in good faith in their ordinary meaning, and give them weight, give them life. We're not asking you to add any words, subtract any words. Contrary-wise, we contend that they are. And this is the arbitration provision that they're putting forward. This is the Article 2 that they're mandating. And the text in red are the additions that they want to make. Article 1 means nothing. And then, in order for there to be consent, of course, forget about Article 1, but we also need to forget about Article 3, even though it's in the same paragraph 3, even though it's in the same article, because it really adds nothing in terms of context or in terms of interpretation to any of the preceding paragraphs. But they say there needs to be consent as to whether it's going to be a single arbitrator or a tribunal, and then there needs to be further consent as to whether it's going to be a special arrangement or if it's going to be uncitral. And if none of those agreements are had, notwithstanding the language in paragraph 1, notwithstanding the language in paragraph 3, and notwithstanding the language that exists in Article 2, there is no consent, and this tribunal lacks jurisdiction. But we're also here because there was an investment. And Mr. Lee-Chin, in June of 2013, acquired La Jun and the land that enveloped and underneath of Duquesa landfill. And I think a little history into that is important, because through this very academic debate, this jurisdictional debate, we're forgetting that there has been an investment here. And that the defense that's being posited, notwithstanding the actions of the Dominican Republic, is that forget about it. It's irrelevant. The fact that it's been expropriated means nothing. The fact that Mr. Lee-Chin no longer operates that facility, the concession for all practical purposes is dead. Legal actions have been brought by the Dominican Republic to try to undo the concession that was previously granted. Notwithstanding that they militarized the facility to expel his people from that area, that it's all for naught. The Dominican Republic owns the keys to how any dispute can be resolved. And not only does it own the key, it has the absolute power of veto. If an investor, notwithstanding the treaty, brings an international arbitration, if they say no, where does he go? To local courts? Under their analysis, I assume that even then they have the veto power. Domestic arbitration, I assume even then they have the veto power. But this is the concession that was entered into in 2007 between La Jun and the Ayuntamiento de Santo Domingo Norte. And what was it for? The administration of the Duquesa garbage dump. And it was exclusive. It was an exclusive concession. And these are all documents that were reviewed by Mr. Lee Chin leading up to the investment. And on the 7th of April of 2009, what happens with that concession? Well, it's extended for a period of 15 years. And what happens going forward as this project is moving, this project is living? What is the Dominican Republic saying? The Dominican Republic is saying in November of 2010 that the contract, the concession, is in absolute conformity with Dominican law. That's not my affirmation. That's not Mr. Lee Chin's affirmation. That's the Dominican government's affirmation. Now they take a completely different position because they want La Jun gone. They want Mr. Lee Chin out. Now they say that somehow this concession is violative of Dominican law. What else does it say with respect to La Jun's compliance? Well, they say in November of 2010 that La Jun has, and I'll jump into Spanish, ha cumplido,
has complied and complies with its obligations.
Do they say that just once? No. Several years later, in a signed declaration executed by the mayor of Santo Domingo, they reaffirm that La Jun is appropriately complying with all of its obligations under the concession. The concession complies with Dominican law. La Jun is faithfully complying with its obligations. Don't take my word for it once, La Jun. Let me ratify it. Let me confirm it on multiple occasions. And what does this trail of compliance lead us to? Well, it leads us to a foreign investor who had previously invested successfully in the Dominican Republic to make another investment, a multi-million-dollar investment into companies that own the concession and into land. And incredibly, what happens almost instantly after this acquisition is made? This is what happens. They begin to tamper the Dominican Republic with the investment. They begin to push Mr. Lee Chin. They begin to say that, you know what, there's no concession for you, sir. And it prompts Mr. Lee Chin to send a direct email to the Vice President of the Republic, the Dominican Republic, in November of 2013. And Mr. Lee Chin makes clear in that letter, in this email to the Vice President of the Republic, the concern that he has, and that it was his expectation that the rule of law would be respected. It was his expectation that a foreign investor would not be pressured to pay a bribe. And that he would be able to enjoy an opportunity to develop what he had planned for Duquesa, which included a methanol plant. Now, luckily for Mr. Lee Chin, then, the Dominican Republic came to its senses. And the actions to thwart his investment came to naught because there was a settlement agreement in February of 2014. And in that settlement agreement, again, the government confirms that La Jun has the resources to dutifully comply with the contract and that LAJUN has demonstrated the economic solvency and financial strength to continue to operate that concession going forward. But it goes on in this first settlement agreement. And it goes on to posit under the paragraph, Spanish, estabilidad.
Legal stability. The ASDN guarantees to LAJUN the peaceful remainder and enjoyment of the rights and prerogatives granted by the agreement to administer the Duquesa landfill.
Going to continue to make trouble with LAJUN. They're not going to continue to thwart the investment. They're going to behave appropriately and guarantee the judicial framework that's necessary so that they can meet their contractual obligations. Now, was that promise kept? Sadly, it wasn't. In December of 2016, the municipality enters the landfill with firearms. Have to confront that challenge. In March of 2017, the state blocks the entrance of the landfill with the municipal garbage trucks. Again, breaching their obligations set forth in the Second Amendment. This leads to further discussions. Mr. Lee Chin again demanding that his contractual rights, his treaty rights be respected. And there is a second settlement agreement in May of 2017. That date's important. May of 2017. A second settlement agreement. And what does that second settlement agreement say? What does the municipality represent? In Article 3.1, it says that the municipality has no claim against LAJUN. Nothing. It scoured the history of the contractual relationship. It scoured the good and the bad. And it's come to the conclusion, which it affirms in this document, that it can posit not a single claim, not a single demand against LAJUN. But does it stop there? No. It goes on. And in Article 4, they give a release. They give a release. And they say, hey, any possible claims that I could have had, known, unknown, etc., I'm releasing. We're going forward now with a clean slate. And what was the trigger that dealt with this Second Amendment? It was the tipping fee. How much could LAJUN charge the municipality for every garbage truck that it dumped in the landfill? And LAJUN's position was the tipping fee was exceptionally low. It had not been incremented consistent with the contract for many, many years. And they felt that an additional, an incremental, an increase in the tipping fee, they being LAJUN, was necessary. And the agreement that was struck there was an agreement where it was in the press, they shook hands, and it was municipality, pick an international expert. And whatever tipping fee is set by that international expert, even if it's a penny, it's the tipping fee that we will live by. And the Dominican Republic selected that international expert, JICA. And they prepared a report. Regrettably, that report was supposed to be shared with LAJUN. It never was. Ultimately, it was found in the World Wide Web because everything is findable in the World Wide Web. But what did this report say was the appropriate tipping fee? Well, there you go. What was being charged thereabout at the time was approximately $3. And what was the tipping fee that, according to the international expert selected by the Dominican Republic, was the right amount, or the average amount? 20. Not 3, $20.43 per ton. What's the reaction from the Dominican Republic here? This is 3 months after, less than 3 months after the second settlement agreement. Less than 3 months after the release. Less than 3 months after the affirmation that they have no claims. What happens? They file an action, un recurso contencioso administrativo that seeks to nullify the concession. Does it stop there? No. In August of 2017, dump trucks were no longer sufficient. Now they just dump the garbage at the entrance to block their ability to operate the facility. And if this obstruction, if this violation wasn't enough, well then you know what? We'll just show up with military force and we'll force you to leave. Which is precisely what happened. So although we can operate this dispute in a vacuum and look at the niceties of how under international law a sovereign grants consent, it needs to be considered that we're sitting here with an investor that assumed that there was rule of law, that assumed that his investment would be protected, and that assumed that the treaty, the CARICOM Dominican Republic Treaty, would grant him the protection that the sovereign was unwilling to grant to him through due process in the Dominican Republic. And confronted with this reality, is there frustration? Yes, there is. Because the investment was made. The concession is gone. The land is no longer his. So what's the result? The result is Mr. Lee Chin says there's a treaty, and I'm going to trigger that treaty. And that's triggered through the 19 December 2017 Notice of Controversy that we sent, Hogan Lovells, on behalf of Mr. Lee Chin. And there we stated the state has consented to submit this dispute to arbitration. And we sent it to a lot of people in the Dominican Republic. Lots. And we got a response on the 16th of March. And in that response, did the government come out and say, whoa, wait a second, we haven't consented to jurisdiction. The UNCITRAL rules don't apply. Well, I mean, Article 1 isn't a consent. We need to agree on special rules. We need to agree on 1 or 3 arbitrators. We need to agree on whether a special arrangement can be negotiated. They didn't dispute any of that. What they said, and the letter is very interesting, it says, para nosotros, I apologize, jumping to Spanish.
For us, it is important to underscore the fact that the arbitral claims filed against the Dominican state and which we are supposed to abide by because of our legal framework are of the highest importance, and the same are given priority treatment.
Oh, it's not enough. They say arbitration because they knew that they had consented to arbitration. They knew that that Mr. Lee Chin, pursuant to Article 1, had the right in that laundry list 1, 2, 3 to select international arbitration. They had consented unequivocally to his ability to do just that. But if that letter isn't enough, what happens? There was in large measure silence. The cool-off period came and ran. And that left Mr. Lee Chin with a choice. What do I do now? Do I sit here and wait for the phone to ring and assume that the Dominican Republic is going to say, Mr. Lee Chin, I'm sorry, how can we make this right? That call never came. So an arbitration was initiated under the UNCITRAL rules. And again, in that request for arbitration, notice of arbitration, we noted that the Dominican Republic expressly consented in the treaty to submit to arbitration all disputes with Jamaican investors. That was the allegation. And again, on the 18th of May, the Dominican Republic responded. Here's another opportunity. Scream from the mountaintops. We didn't consent. There's no jurisdiction. Forget about UNCITRAL. I don't want to name anybody as an arbitrator. What is their response? Their response, among other things, on the 18th of May, is to let us know, jumping to Spanish.
Furthermore, we take this opportunity to make it clear that in this proceedings, to which potentially the 1976 UNCITRAL arbitration rules would apply.
They know that those are the rules that apply by default. They acknowledge it here. And if this isn't an acknowledgement, it's an acceptance that those are the rules that they're willing to live by for purposes of this arbitration. Those aren't my words. Those aren't Mr. Lee Chin's words. Those are the words of the sovereign in formal correspondence. And does it end there? No. A few days later, on the 24th of May, we get another letter from the sovereign. All of this discussing what? An arbitration. We're not talking about a local piece of litigation. We're not talking about a domestic arbitration. No, we're talking about an arbitration. And what do they say? Jumping into Spanish.
Further to our letter dated 18 May,
where they recognize that the UNCITRAL rules apply to the arbitration, they go ahead, and I think, great decision, they nominate Professor Cohen. So we had nominated our party-appointed arbitrator. They have now nominated their party-appointed arbitrator. So we know that this arbitration, you don't have to be Albert Einstein, is not going to be resolved by a single arbitrator. It's going to be resolved by 3. And that was the understanding that we reached. And again, this is in May. Now, what happens in June? And this is a seminal event. In June, we get a letter, an email, from Adeline Contreras, who I've known for many years and I respect a great deal. And Adeline says, well, we have engaged counsel. And who have they engaged? Of course, Curtis. And my friends and colleagues at Curtis. And for the first time in this correspondence, in this email, now the idea of a lack of jurisdiction, that little seed begins to get water. And we begin to see how they try to perfect it. Put the genie back in the bottle, forget those letters. And what do they make clear in this email? Well, they say, bless you, sir. They say in paragraph 2, jumping to Spanish,
the parties have not reached any agreement to refer to an arbitration, neither under the UNCITRAL rules or any other type of arbitration.
In fairness to this communication, it appears to be in direct conflict with the letters that we just saw in May, where they agree that the arbitration is going to proceed under UNCITRAL. But now, no, that doesn't work anymore. We want to preserve our jurisdictional objection. And we want to now argue that somehow there isn't consent. And again, with all due respect to my colleagues, the purpose of pointing out these prior cases is to draw parallels to arguments that have been made in matters where Curtis was counsel. And in the case of Venezuela U.S. versus the Bolivarian Republic of Venezuela, where Curtis was counsel for the sovereign, they made a very similar jurisdictional objection. And what was that objection? The respondent objects to jurisdiction of the tribunal on the basis that Article 8 of the treaty does not provide a valid and effective consent to arbitration. This is a defense that Curtis makes frequently. And what was the result in this case? Well, majority decision confirmed jurisdiction. Now, maybe it was just this one case where Curtis made that argument. Well, no. In the case of Garanti, and we heard a little bit about that in the opening presentation posited by the Dominican Republic, Again, counsel for the Republic, Curtis. And what do? They object. Again, to jurisdiction. Turkmenistan did not consent to ICSID arbitration. What was the result? Jurisdiction upheld by the tribunal majority. And what's the argument here? Again, ignoring the correspondence, ignoring what we believe was the belief of the Dominican Republic when this action was initiated. The argument is, jumping to Spanish, no contiene.
It does not contain the Republic's consent to international arbitration.
That it has posited time and again, sovereign after sovereign. And what do they put forward for this? No supporting expert, no supporting fact witness, no supporting documentary evidence other than the preparatory works of a few rounds that they by happenstance happened to find after the discovery due date because they wrote a letter after the fact to the Dominican Central Bank. All the other round preparatory works, those were maybe burned in the fire, thrown away, lost. This is all they could find. But to them, this dispute is so crystal clear, notwithstanding the reams of submissions that have been posited, that they don't need anything other than the 2 paragraphs of the treaty, 3 paragraphs. Jurisprudence and arguments posited by Curtis Mallet. And understand, arguments by counsel, that's not evidence. That's not evidence. And we've heard this morning what we heard in Curtis's submissions, that our witnesses are wrong. Our expert isn't an expert. He's my co-counsel. Please. He's not my co-counsel. He's an expert. And to insinuate that he's my co-counsel, candidly, is inappropriate. And our fact witnesses, oh, they're just old men. They can't possibly remember what they did 20 years ago in the negotiation of a free trade agreement. And the Dominican ambassador, which we heard a little bit about in opening, the Dominican ambassador who corroborated our fact witness, the Jamaican ambassador, well, he too is wrong. He too forgets. And is there a single Dominican witness that says Ambassador Zaide was wrong? He's crazy. That wasn't our intent. Is there a single Dominican witness that was willing to say that the ambassador from Jamaica is wrong? That his interpretation is flawed? That his recollection is lunacy? No. And is there a single expert in the universe of experts that's willing to take on what our expert said? Where is he? Where is she? And as my colleague said, it's very telling that the claimant did not attack X. Well, it's very telling that they could not find a single expert to support the proposition that they're asking this tribunal to adopt. And what's the gain? Well, the win is we posit these jurisdictional objections, and there's a chance that we'll be successful. And if successful, well, you know what? They get a hall pass. Mr. Lee Chin's investment goes up in smoke, and we're happy to invite him to the tribunal, to the Dominican Republic courts, to see if he can be vindicated. Maybe if they consent. And what have they won? From the filing of our notice of arbitration to today, 693 days. Most investors would pack their bags, but Mr. Lee Chin continues. Yes, sir.
Sorry, Mr. Lorenzo, if I could ask a very quick question. In your timeline, when was the first time that the state raised or reserved rights in relation to any jurisdictional objection?
We contend in the email that I showed you, sir.
Which would be, what, the 11th of June?
Correct.
Thank you.
So let's now turn to the treaty. And we'll walk through various of the arguments that we have made and try to address certain of the theories that have been posited by the respondent. And we'll begin with indirect investors. The definition, we begin with the definition, covers any natural person. Well, Mr. Lee Chin is a natural person, and there's no dispute that he's a citizen of Jamaica. Beyond the statements, this is one of the statements that I read earlier, there's the allegation that somehow he's not a real investor, that he's not serious. Well, we know that's not true. We know the reality of Mr. Lee Chin. We know that he's a serious investor, and we know that he didn't just enter the Dominican Republic yesterday. And we also know that he provided a declaration in this case in support of his jurisdictional position. And regrettably, they don't want to talk to him. Regrettably, they don't want to cross him. And that's telling. And one needs to wonder why. With respect to investment, what investment is covered? Every kind of asset. Not exclusively those listed. Any kind of asset is covered as an investment, which would include land, which Mr. Lee Chin owns, which would include a majority interest in La Hun, which Mr. Lee Chin owns, and which would include the rights to the concession that was held by La Hun. And the argument that's made by the Dominican Republic is that this particular treaty, jumping into Spanish,
does not protect indirect investments nor indirect investors.
That's the argument. And they continue to say, in the absence of the specific language in the text of the treaty, this investment, indirect investment, is not covered, and they cite the following case, noted in paragraph 159. And it's a case that they like to cite when they make the indirect investor jurisdictional objection, which they do time and time again. So let's look at that. Cemex versus the Bolivarian Republic of Venezuela, represented by Curtis Mallet, they make the same argument. Article 1A of the Dutch Treaty defines investment to include every kind of asset, just like the CARICOM Treaty. Makes no reference whatsoever to the subject of ownership or control, whether direct or indirect, or the location. According to the respondent, the sovereign, represented by Curtis, the Dutch treaty does not cover indirect investors. Same argument they posit here. And almost a cut and paste, only translated into Spanish, of what was incorporated in their memorials here. They say, well, look at Burscharter, and I apologize for the pronunciation, versus Russian Federation. What was the result? The tribunal there said, the tribunal notes that there is no explicit reference to direct or indirect investment in the BIT. The definition of investment given, that article is very broad. It includes every kind of asset, like our treaty. And then the tribunal concludes, thus as recognized by several arbitral tribunals in comparable cases, the respondent's objection to the tribunal jurisdiction under the BIT cannot be upheld. Well, was it just in that case? No. In Mobile versus Venezuela, same argument is made. Same argument is made. And what's the decision of the tribunal? Makes the exact same observation. The tribunal notes that there is no explicit reference to direct or indirect investment, like our treaty. The BIT does not require that there be no interposed companies. Therefore, a literal reading of the BIT does not support the allegation that the definition of investment includes indirect investment. Investments as defined in Article 1 could be direct or indirect, as recognized in similar cases by ICSID tribunals. And confronted with decision after decision, not isolated decisions, decisions where they made the same argument, decisions where that argument failed, what do they say here in their reply memorial on page 51 of the PowerPoint? Jumping into Spanish.
the respondent does not ignore the existence of these decisions. They are incorrect, and they should not be abided by this tribunal.
Those decisions exist. They recognize that the jurisdictional challenge failed. But according to the respondent and their counsel, you can ignore them. Because respectfully, they're wrong. Well, we may be wrong. Richard Lorenzo may be wrong because I don't fancy myself a legal scholar. But these are the arbitrators that agree with our point of view. So if our position is wrong, which it could be, well then all of these other arbitrators who have addressed this issue are similarly incorrect. Turning to the issue of consent. And if we focus on paragraph 1. Yes, sir.
Mr. Lorenzo, could the claimant please identify the different cases in which all these arbitrators allegedly accepted the idea of direct or indirect? Not now, of course.
It's in our memorial, Professor Cohen, and we'll provide that information in the page site for your benefit.
Thank you.
May I proceed, Mr. Chairman? Thank you. Turning now to the binding offer of international arbitration provided by the sovereign in paragraph 1. And there's a lot of debate on shall. What does shall mean? Is shall permissive? Is it mandatory? Is it obligatory? What does it mean? And there's even some discussion that somehow or doesn't mean or, all doesn't mean all. It actually means and, or, y, to use Castellano, which I'm far from a great Spanish speaker, but I'll do the best I can. We believe shall means shall. And that shall is a word that has ordinary meaning and should be given its ordinary meaning. And interestingly, in their first memorial, they seem to agree, they being the respondent, seems to agree that paragraph 1 means something. Now, this is no longer their position. Their position now is that all means e. But when this dispute got started, and when they began thinking about it and trying to build their jurisdictional objection, they looked at the first paragraph and they accepted in principle that controversies could be submitted to national courts, national arbitration, or international arbitration. They don't say all three at once. They don't say that this is some sort of pathological clause because it leads to an absurd result. No. They seem to accept what I think anybody that reads Article 1 would accept, that shall actually means shall. Serán means serán. And there are cases that have looked at similar provisions. One example is Rost-Invest versus the Russian Federation. And there, the treaty language utilizes the word shall. And it analyzes what that word means. And interestingly, there's also a jurisdictional objection. And the respondent there argued that the UK-Soviet BIT does not contain an offer to an investor to arbitrate a dispute. Very similar, if not identical, to the argument that's being made here today. And it notes that in order for there to be consent, it requires a joint referral to international arbitration. What was the tribunal's ruling with respect to that case? The analysis of that word shall. The tribunal held that Article 8 contains express and unambiguous language in its second paragraph. First, by using the word shall, which makes clear that it is mandatory. The other party does not have to agree again in order to permit the arbitration. And the tribunal went on in this decision that language in that treaty, similar to the language in our treaty, uses language which is found often in other bids, interpreted as binding consent to arbitrate. But is this decision an outlier? How do tribunals define shall? Well, we go back to Garanti, case where Curtis represented the sovereign. Their treaty language, similar to ours, paragraph 1, uses the word shall. Well, is that permissive? Is it a thought? Does it require additional action? Or is it a binding offer of consent? What was the argument that was posited by the sovereign in that case? The argument was virtually identical to the argument that they're making today on behalf of the Dominican Republic. And what's argued is that Turkmenistan has not consented or agreed to participate with this claimant in an ICSID arbitration. And they go on to analyze treaty language that is very similar to the treaty language in the CARICOM Dominican Republic Treaty. And they look at Article 8.1, similar to our paragraph 1. The use of the auxiliary verb shall makes the statement mandatory. Now, I don't believe that that's a crazy idea. I don't believe that shall, that a tribunal making the decision that shall actually means mandatory and not permissive is outlandish or crazy. I think it's right. And the tribunal goes on in analyzing 8.1 and provides that Article 8.1 thus appears to a majority of the tribunal to establish unequivocally Turkmenistan's consent to submit disputes with UK investors to international arbitration. Looking at language similar to ours, analyzing the word shall, and determining that it means what we all know it to mean: mandatory, obligatory, unequivocally. And again, this is a position which is reinforced by our expert, and unlike their expert that doesn't exist, our expert is here, and he will address his report, and they'll have an opportunity to test his opinions at the appropriate moment. Paragraph 2. Paragraph 2 assumes that a dispute has already been referred to international arbitration, thus confirming that consent has already been provided via paragraph 1. We believe that those words, the first part of paragraph 2, where the dispute is referred to international arbitration, means something. It assumes that the dispute, the options that existed in paragraph 1, that the investor exercised its rights set forth in paragraph 1 to choose one of the options, to which the sovereign has already consented, shall. And when and if that dispute is referred to arbitration, well, then action is taken. Now, this provision, where the dispute is referred to international arbitration, is it unique to the point that it's never been looked at by other arbitration tribunals? No. Garanti, the provision that was the tribunal that was reviewing that jurisdictional challenge, looked at similar language. And if you'll recall, Article 8.1 utilized the language shall, and that tribunal determined that shall meant shall. But it also had an Article 8.2 that begins with the following language: where the dispute is referred to international arbitration. Identical to the language in our Article 2. And the tribunal held there that Article 2 only comes into play after the determination has been made under the provisions of Article 8.1 to refer the dispute to arbitration. And we agree. And then, of course, there's paragraph 3. Yes, sir.
Sorry, Mr. Lorenzo, just wanted to check. Are you moving off paragraph 2 now?
For the moment I am, but I do come back to it later.
Okay. Because I'd like to ask a question that I was actually originally aimed for you, and I posed it to Ms. Frutos Peterson in anticipation, are you going to deal with this question of y la parte, the words in paragraph 2? And if not, maybe I can pose the question and you can see if you're going to get there in your...
Sure, that's fair.
If on your case, paragraph 2 was, and I'm loath to use this phrasing, but sort of the menu of options that can be consulted if arbitration is the route that's taken. Of the paragraph 1, you have the 3 options. Paragraph 2, you then start to refine. You either have international arbitration or you have what I would call pure ad hoc or uncitral ad hoc. That's how it could be read. If that were the reading, why would the words "and the party" be there in the second line of paragraph 2? Because where the dispute is referred to international arbitration, the investor, on your case, has the choice now of which route to go. Because in your case, paragraph 1 has already given the consent. So now we're just in a procedural selection mode. But then why would the drafters have "and the party"? Because either it's included, and these are 2 potential interpretations, either it's included out of an abundance of caution to sort of refer to who the 2 parties are that are going to get to enjoy the menu of these 3 options, or it's laden with significance to mean the investor and the party will then go on to agree, and that actually makes the party, the state, an actor under paragraph 2 of some significance. Can you offer any thoughts as to why the wording "and the party" might be there?
Professor
and
Leafley,
if my question isn't clear, then
No, your question is clear.
Okay.
I think I am going to get to it
Okay.
later down the line.
Sure.
If I don't, just remind me and I will address it.
I will do.
Thank you. Paragraph 3. And paragraph 3 is within the dispute resolution article. And I heard multiple times our colleagues on the other side say that the provision needs to be read in a whole, as a whole. You need to look at Article 1, you need to look at Article 2, you need to look at Article 3. But yet they spoke nothing of Article 3. And it wasn't until the tribunal posited the question, which I believe was a fair one, concerning, well, how do you reconcile that there's no consent with paragraph 3? And we don't believe that you can reconcile it. Yes, sir. Sorry,
sir, I have another question.
Sure.
But it relates back to paragraph 2. And again, tell me if you're going to get there.
Sure.
Is it your case, because it's not entirely clear to me, is it your case that uncitral is a default option?
Yes.
It is. And so, can I pose to you a possible interpretation of paragraph 2 which might challenge that?
Sure.
So looking at paragraph 2, you have the first 3 lines, as we've got them on this slide 66 of your presentation. I'm going to switch to Spanish. Actually, yeah, but where the dispute is referred to international arbitration, the investor and the party concerned in the dispute may agree to refer the dispute to, and then I would inject a potential pause there, to an international arbitrator or ad hoc arbitration. So there you have...
Tribunal.
I beg your pardon, ad hoc arbitration tribunal. And then I would propose that one interpretation could be, at that point, you've got a split of options. You've either got international arbitrator, I don't know what that means, whether that's a shorthand for institutional arbitration, or ad hoc. I can only assume international arbitration could be institutional because it's seemingly the only logical alternative to ad hoc. But anyway, ad hoc arbitration. And then I would suggest you can then inject another mental pause. And in fact, from the word "to be appointed" could actually be in parentheses to the end of the sentence, which would then be to be appointed by a special agreement. That's what I would call a pure ad hoc, or uncitral, which is quasi ad hoc, in the sense that it's an ad hoc arbitral tribunal, but under a set of pre-agreed international rules. But then that creates in that parenthetical a choice. I don't easily see the default, and that's what I'm struggling with.
Sure. I'll see if I can, and I am going to go to it further down the line.
And please tell me, just I will stop and won't expect an answer right now.
I break this down line by line in a little bit. I'm happy to do it, try to do it now and address it then later, but defer to you. It's 3 slides down, I'm told. So we'll jump to it. Thank you, sir. I won't belabor paragraph 3 beyond saying that we agree with some of the comments that were posited by Professor Leafley with respect to this. We believe that this paragraph needs to be taken into account when you look at the dispute resolution, paragraphs 1, 2, and 3, and we believe that is supportive of our position that there is consent granted through paragraph 1. Now, let's go to paragraph 2. And we try to break it down in those 3 slices as well, Professor Leafley. And of course, our position is that there is consent at paragraph 1. And if you look at paragraph 1, we contend that if you look at paragraph 1 fairly, the disputes that are being contemplated in paragraph 1 relate to disputes that concern violations of the treaty. So who is the only party that's going to be bringing a dispute that concerns a violation of the treaty? The investor. So the investor in paragraph 1, given the disputes that are defined there, types of disputes that are defined in paragraph 1, is the one that can exercise the option, the laundry list of options in paragraph 1. Here, we exercised our right under paragraph 1 to pursue international arbitration, which we did. And we believe that they consented to that. And we also believe, irrespective of how they want to argue it now, while that process was taking shape, they agreed to a tribunal of 3, and they agreed to the applicability of the UNCITRAL rules. So irrespective of how you break it down, that's a factual question for this tribunal to determine whether or not through the correspondence this is truly academic, and they've agreed to all of these things.
Although, just going back to you on that, you answered me before June 11 was the date where the reservation had been made, and therefore I'm assuming the implication was prior to that there'd been no reservation of rights. But I was looking at the correspondence, and there did seem to be reservation of procedural rights, and so it would be helpful at some later stage, today or tomorrow, just to have a clarification of your position by reference to what is said in the letters, because it's not immediately clear to me.
Okay. So now going to our view that there's default application. Podrán acordar referir la misma a un árbitro internacional.
Could agree to refer that to an international arbitration or an ad hoc arbitration.
Want me to say it again? Thank you. Podrán acordar.
Could agree to refer such controversy to an international arbitration or an ad hoc international tribunal.
Y la parte. That language is there. So the question becomes, do the parties have to agree on an international arbitrator or a tribunal? Our contention is, if there is no agreement, what flows thereafter? What flows, the parties then can endeavor to agree on un acuerdo especial, a special agreement. And if they do not agree on a special agreement, well, then the default are the UNCITRAL rules. And pursuant to the UNCITRAL rules, because the arbitration is going to proceed bajo las reglas de arbitraje.
According to the arbitration rules of UNCITRAL,
in which the arbitrators, the number of arbitrators, and how they're going to be selected.
Mr. Lorenzo,
Yes,
I would like to understand the sequence. So first, the dispute is referred to international arbitration. And then there is the possibility of agreement between the state and the investor about designing a single arbitrator or a tribunal. And if there is no agreement, then uncitral.
Correct.
But what is the sequence? So the first step.
The first step, we contend, Article 1 provides consent. And we believe that Article 1, when you look at it and you look at the types of disputes that can be brought in Article 1, that the investor has the right to choose the three options, the laundry list of options that are there. In this particular instance, in our case, we chose international arbitration. And then we notified our counterparty that we initiated that arbitration, which leads us to the first portion of Article 2. And I'll read it in Spanish. Cuando la contro-
When the dispute is referred to international arbitration, no,
And we believe at that point, they've consented, the sovereign has consented to international arbitration. What follows thereafter are the mechanics of the arbitration process, not the issue of consent. It is the nuts and bolts of how that arbitration is going to proceed.
So the claimant's assumption is that the choice among the three possibilities is for the investor.
That's correct, sir.
That's your point of view?
Yes.
Thank you.
An additional point on this.
Yes.
And when, if in any moment, when the state has the possibility to propose the agreement. So you brought the action, and at that moment the state should propose an agreement to select arbitrators, and if not, you think that the door for uncitral rules is already open.
Mr. Chairman, if I understand the question, I'll try to use the example of our particular case, because
Please,
they're
go ahead.
concrete examples that we can look at. We initiated the arbitration, and we proposed the nuts and bolts of the arbitration process. If memory serves me, we actually proposed that it be administered by the PCA. Ultimately, we're being administered by ICSID. We proposed a methodology for the appointment of arbitrators, and we proposed not the 1976 uncitral rules, but the 2010 uncitral rules. We posited that proposal to the sovereign. The sovereign came back immediately and said, okay, 3 sounds right. You pick one, we pick one. We don't like well, I don't want to say that they said they didn't like the PCA, because that's not accurate. They said we prefer that it be administered by ICSID as opposed to the PCA. We agreed to that. And then ultimately they said, the respondent posited that the 1976 rules should be the applicable rules. And we said, okay, fine. And that is why, in this particular case, there is no response to our request for arbitration, because the respondent correctly pointed out that in the 1976 rules, there is no obligation to file a formal response to the request for arbitration. So in that case, what was the timing, Mr. Chairman? The way the process worked live and in color was, in our request for arbitration, we addressed many of the issues that are in the nuts and bolts of Article 2, and through that process, they agreed to, number one, that it wasn't going to be un árbitro internacional, a sole arbitrator. They agreed that it was going to be un tribunal, a tribunal of 3. And they agreed that, well, we couldn't agree to a special, un acuerdo especial, so we ended up in the default of uncitral, which to us was the default that needed to be pursued, and they ultimately acquiesced to it. And we are proceeding under, as I understand it, the 1976 uncitral rules as we sit here today.
Thank you. Go ahead.
Thank you, sir. So, in summary, our position with respect to these two provisions: paragraph 1 provides binding offer of ex ante consent to international arbitration. Paragraph 2 follows consent and only comes into play when a dispute has already been referred to international arbitration, thus the language, the first few words of paragraph 2. the parties may agree to a sole arbitrator or ad hoc tribunal, which, absent special agreement, proceeds under the UNCITRAL rules. Yes, sir.
I'm sorry. Putting aside the question I asked a moment ago about what actually happened in the correspondence in terms of reservation of rights, what would you expect a state to do in engaging in a notice of arbitration that wouldn't have the effect of essentially giving up the consent that you say was given up under paragraph 2? And what I'm trying to pose here, of course, with competence and the acceptance that you may have to respond to a notice of arbitration, and that the institution of arbitration allows the question of jurisdiction to be decided by a tribunal. I can see a slight catch-22 for a state in one interpretation, that you're damned if you do and you're damned if you don't. If you don't engage at all because you can't, as a state, you don't want to touch anything, then the state is left in a tight spot where they have to push back from the table and not engage in the slightest. And that would run some serious risk. Alternatively, the state could engage, as it did, but then that immediately qualifies under your interpretation of paragraph 2, which could be seen as a little unfair for a state if they are only wishing to find the forum to challenge jurisdiction. So I just wondered, is there a way of threading the needle where a state is capable of responding to a notice of arbitration but doesn't fall foul of immediately giving up that consent to specific types of arbitration?
I'll give it some thought, and I'll get back to you, but I do think, just one example, Professor Leafley, is obviously when the notice of controversy was received, the sovereign could have said at that moment, because at that point they understand that we're exercising certain rights under a specific treaty, and they could have very easily said, listen, we've not granted our consent here, period, full stop. They could have said a whole host of things that would have been more in line with the jurisdictional defense that they're now positing in this case. When our notice of controversy came out, we said that they granted consent, we identified the treaty, and the response that we received back spoke of the issue of arbitration. Didn't say what was in the email of, I think it was June or July of 2018, after Curtis Millet was retained as counsel, that said, okay, UNCITRAL, but by the way, don't allow that to assume that I'm agreeing that it is UNCITRAL. And my thought process, Professor, is that I believe that at the time that the notice of controversy was presented, the Dominican Republic believed that they had given consent, because their correspondence, the first correspondence, talks about arbitration. It talks specifically about arbitration. It uses that word. And the sovereign, which is sophisticated, represented by competent lawyers, if they genuinely believed that they never granted consent in that treaty, and that arbitration could not move forward, international arbitration could not move forward unless they consented again, and that this laundry list of things needed to, after the fact, be agreed to, they could have easily done that. And in this case, they did not. I defer to the tribunal.
We're 1 hour into the presentation and we're about half into the slides, so if the tribunal thinks that this is a good time for a break. Yes. So, I should have looked back.
Demandada, por favor.
Respondent? No problem. Very well. We will have a recess of 15 minutes.
You have 1 hour and 2 minutes left.